My name is Mark Cooney. I'm the Executive Director of the Kimble Center for Legal Drafting, and I am delighted beyond measure to welcome all of you to our annual seminar. In case you're not familiar with the Kimble Center, our mission is to produce clear, easy to understand documents for lawyers, for consumers, for free. I'm so proud that our first effort, our Power of Attorney, received the Clear Mark Award for the legal documents category, and also received a Right Plus Award from Right Limited in New Zealand. I am, ladies and gentlemen, hosting from a very hallowed place here. I have, after Joe Kimble retired from active teaching, I snuck in and took over his office. Ladies and gentlemen, it was within these four walls that Joe Kimble redrafted the Federal Rules of Civil Procedure and the Federal Rules of Evidence. Right now, as we speak, I can guarantee you that there are lawyers and judges across the United States looking over those rules, and they are all the beneficiaries of Joe Kimble's careful work here. He'll say with a committee, yes, with a committee, but right here, right at this desk, people. So if that's not inspiring, I don't know what is. So again, welcome. We are delighted to have a superstar panel here, to put it mildly. And I'm going to give each of them a proper introduction. We'll have Professor Peter Butt first, Professor Julie Clement second, and Professor Joseph Kimble. That's a name you're hearing a lot. Third, if you have a question, you can post it in the chat. We will try our best to get to it, but I can't make any promises. If you've registered, we could even maybe follow up with you in the coming days by email. But again, welcome. And with that, let me introduce our first speaker, Professor Peter Butt, who is enjoying his breakfast. Indeed. Presenting for us. It's probably about 6 a.m. in Sydney right now. He's Peter is is Emeritus Professor of Law at the University of Sydney. He holds 4 degrees and is an attorney in Australia, and also is an honorary member of the Inner Temple in the UK. He's written books on land law and conveyancing, including a book on the rule against perpetuities. Yikes. That's a brave man. And also, maybe more relevant for our purposes here today, he has written books on legal drafting, including Modern Legal Drafting, 3 editions, Modern Legal Usage, The Lawyer's Style Guide. He co-edited, and I may mispronounce the name, Pice's Elements of Drafting. He's a co-editor of the first edition of the Australian Legal Dictionary and several editions of the Concise Australian Legal Dictionary. He was a founding director at the Center for Plain Language at the University of Sydney, and is a former president of Clarity International, an international organization devoted to clear legal writing. He has lectured in many countries. In fact, I've decided from looking at the list that it'll be easier to say he's never presented, as far as I can tell, in Antarctica. Other than that, he's done it. And until recently, he taught an annual Master of Laws course in legal writing at the University of Cambridge. I am so pleased to introduce, and please join me in welcoming, Professor Peter Butt.
Thank you, Mark. I'm not sure I recognize myself, but it's very kind of you. Yes, if you have to excuse my slightly throaty voice, ladies and gentlemen, it's because I'm talking to you at breakfast time, before breakfast time, indeed, as Mark very generously reminded me. My topic is to introduce what I think is one of the overlooked aspects of plain language, certainly amongst many practicing lawyers, practicing attorneys, and that is how we should structure our legal writing, any kind of legal writing. But I'll concentrate on 2 aspects of legal writing. One is advice writing, which is quite a common topic, I think, the structure of advice writing. But then the second one will be document drafting, legal documents, deeds, contracts. Are there aspects of structure we could equally apply to those kinds of documents, which is something I think lawyers more rarely think about? So first of all, I'm going to try and share my screen with you. as I was saying to Joe yesterday when we had a bit of a trial run here, I think I have a slimmed down version of the product, but here we go. You're going to see all my files just in a minute while I find the relevant one. Then I'm going to share my screen with you. Okay, now you should have a page on your screen saying the importance of structure, a relatively new concern for lawyers, question mark. Do we have that? Thank you very much. And it is a relatively new concern for lawyers, I think. You'll find you can, by the way, you can zoom in or out of this document on your screens as you like. I think as you see it, you'll see the whole page. There's only 2 lines on that page, but you'll see the whole page. But please feel free to zoom in or out, and I'll give you some ideas what to look for as we go through. But I say a relatively new concern because I think for lawyers, certainly in my part of the world and in Britain, the important thing was that in your writing, you covered the relevant points. It didn't really matter where you put them. If you're writing an advice, you'd cover what you thought were the important points, and maybe woe betide it ended up before a judge, you'd be asked, did you cover this in your advice? And yes, here it is, Your Honour. I'm pointing to it. It's on page 3, at the bottom of the page. Where you put your important information didn't really matter. As long as it was there, long as by hunting and pecking a judge could find it, you get a big tick. And so with documents, if you have a contract or a deed of some kind, and the question is, did you cover off this particular point? Well, it's on page 57, clause 53.1, subparagraph A. There it is, Your Honour. Good, you've covered that. Doesn't matter where you put it. The legal question is, did you say it at all? But we've learned, I think, through hard experience in the world of plain language, that's not really good enough. When the plain language movement started, at least here in Australia, maybe 30 years or so ago now, we concentrated on what I would call the finer points of writing. Questions like, well, I think the things that Joe and Julie are going to be talking about later on, questions like, are my sentences too long? Are my words too complicated for my audience? Am I lapsing into the passive voice instead of trying to find an active way of saying this? And those things remain important, of course, and we'll be talking about them later on, as I say. But I think we've learned in our experience that there is one overarching point, and that is, have I presented the material in the best way possible for my particular audience? And it's not in plain language, in inverted commas, it's not in plain language, I think, until we've given attention to what's the best structure for my audience. Now I'm going to go to the next page, and I think you should find me with the heading Key Point, Audience. What is the best structure for my audience? And this, I think, is the test. This is my homegrown test. Will this structure help the reader to understand this document on a single reading? Will the structure I've adopted help the reader to understand this document on a single reading? Because for me, that's the test of plain English. Can my audience understand, my target audience, understand this piece of writing, this document, on a single reading? I suppose it assumes a reasonably interested target audience. Will my audience, assuming reasonable interest in the subject matter, because not everybody is interested, we have to read things, don't we, that we're very uninterested in or disinterested in from time to time. But assuming an interested audience, will they be able to understand it on a single reading? That to me is the test of plain language. And that's where structure really comes to the fore. Have I chosen a structure that will best let them understand, take in my document on a single read through? If they have to read it more than once, chances are that we as the writer have failed in our attempts. Now, okay, let's get down to the nitty-gritty. What's the best kind of structure? Well, for any kind of legal writing, I think there are probably 3. There may be more. We may know them. The most common one, I think, and particularly I know this is Joe's term, I think, is a front-loaded structure. So you ask, well, what's the main point here in my document, my piece of writing? Is it possible to move it up front? Front load the key things that will interest my reader. Not that will interest me necessarily as the writer. I may love boilerplate, as I do, I have to admit sometimes, but that's not going to interest my reader for sure. So that's one form of structure. Another one is, well, sometimes if you try and front load key points, you may end up presenting something that's slightly fractured to your reader. Maybe better, and I'm going to give you some short illustrations of these in a minute, maybe better to have what I call anyway a thematic structure where you group like with like. If I pick out the 3 or 4 really main points and front load them, I'm going to produce something that's a bit illogical for this reader in this context. So maybe second best, but this is better than nothing. I'll at least group like topics with like topics. So maybe I'm drafting a mortgage. And I suppose there are 2 or 3 provisions in a mortgage which may be key, and you could move them up front, but it's probably going to be such a long document, best to at least group related matters. So I'm going to deal with what are the mortgagors, what are the borrower's liabilities, what are the lender's responsibilities, what are the payment obligations, sort of group those things. What are the default consequences? Group those things. What are the powers of the mortgagee? Group those things. And so you haven't fractured the commercial structure by trying to front load 3 or 4 main points, but you've helped the reader by saying, well, I'm going to deal with all this in this part, all this in this part, and so on. And then there's a third structure which suits, and I'll give an example in a minute, which suits some documents in particular, I think, which is what I've called chronological, where you step through the transaction step by step, particularly if the reader is going to know basically how such a transaction unfolds anyway. Why fracture the accepted structure of this transaction by taking key points out of their chronological sequence? So let me go to the next page. So let me give an example of an advice. Now, we've all been through this, haven't we? But when you look back over the years, it's quite interesting to see how long it's taken we lawyers to get to this kind of structure in a legal advice. This was the traditional format, wasn't it? So you would have, it reads like one of Joe's stories, one of Joe's children's books. So you would have, forget what's on the screen for a minute, but this is how it would go, wouldn't it? You'd have, this is the question you've asked me, dear client. Now, here are the background facts. So we get our that question in context. Here are the background facts, which, by the way, the client probably knows anyway, but we're probably just covering our own backs by putting out the facts. What are the assumptions here? Here's the law. Now I'm going to apply the law to the facts. And finally, light bulb, here is my answer, 4 or 5 pages on. That's how a traditional legal advice would run, yes. That's how, certainly in my part of the world and in Britain, judgments would run, a bit like a detective story. You've got to wait to the end before you get the answer. But now we've learned from hard experience with clients, well, certainly I say here in Australia, clients have said, that's not good enough. I want a better structure. And so now we structure our advices this way. This is a front-loaded structure. This is the question you've asked me, and straight away, here's my answer. Maybe my answer here is in a slight summary form because it's going to be a bit of a complicated answer. You've asked me a complicated question, so I can't just give you the answer in 1 sentence, but here's a brief answer to your question. So straight away, the client knows what the answer is going to be. And then you say, well, read on if you're interested, more or less. And here's the law. Here are the background facts, which I know you, dear client, probably know, but let's put them down because then you can see what I've thought is important here. And finally, if you need to do so, let me go through the answer again just to confirm all of this. But I think that is the modern structure of legal advice. Am I right? I think, but it's surprising if you look back at legal advices 20 or 30 years ago, very few people would have adopted that client-friendly structure. Well, I think I take it for granted now. That's how one now structures a legal advice. Here's my difficult question, though. Can you apply that kind of structure to a legal document? If we think so hard about what's the best structure for my reader for an advice, well, shouldn't we also be thinking what's the best structure for my contract, for their contract that I am drafting for them? And then I think you can, if you want a front-loaded structure, you can sometimes do that with a legal document. It takes a lot of work because, as I said before, legally, the important point is, well, have you covered this content, not where is this content? But I would say that any well thought out document now, contract, deed, should give some thought also to structure. And so if you want to front load it, if that's the structure you're using, well, maybe this is the way you do it. My co-author of the early editions of Modern Legal Drafting used this phrase, Richard used this phrase, heart of the deal. What's the heart of the deal commercially for these clients? Well, can you put that up front? Can you adopt a front-loaded structure for this contract? If you can, put that up front. Then next you deal with the rights and obligations of the parties, and you leave the boilerplate till the very end, yes? So you could, if you wanted to adopt, if it was feasible, a front-loaded structure for a contract. It can sometimes be done. It's a bit of work for the lawyer for the first time. You've got to move these clauses around, but you can do it. And that's the kind of structure, I think, that you would come up with. Let me take you to my next page because I want to now show you a diagram. One of my Australian colleagues, you should see two graphs or two pictures on your page. One of my Australian colleagues was asked by an Australian law firm, a very large law firm, to see whether their legal contracts met best business writing practices. Do our contracts meet best business writing contracts? We're getting some pushback from our large commercial clients. They don't like the style of our contracts. They're finding them hard work. Do they meet best business writing practices? And so this friend of mine, the poor man, was given hundreds of very voluminous documents across all practice areas and asked to read them. He's not a lawyer, asked to read them and see whether they met business writing practices. And he ended up, he drew it diagrammatically, his results. He ended up with that first diagram on your page, not this. And he said, if I look at your documents, he wrote this in a large report, which hasn't been published, sadly. The client firm didn't come out too well. I suspect that's why. He said, if I look at your documents, I find that each 20% of the documents contains about 20% of the commercially important terms in this transaction. I'll just repeat that. Every 20% of the document contains about 20% of the commercially important terms in this document. So your important terms are spread pretty evenly throughout the whole document. And it means that your client has to read the whole of that document quite carefully to understand or to find whether you've covered off the important points for them. They can't allow their concentration to lapse. They have to read this thing from cover to cover because they're looking to make sure you've covered off the important points. And he said, my friend said, actually, if you wanted your document to meet best business writing practices, it should be more like the second diagram. So if you're going to adopt Joe Kimble's front-loaded technique, you should find the first 20% has something like 40% of the main commercial terms. The next 20%, something like 30% of the main commercial terms, and then you'd slowly fall away from the main commercial points. So you should end up with a document diagrammatically like the second one on the page. the main commercial points are moved towards the front of the document. And then if your client wanted to relax when they got to the boilerplate clauses, well, they can do so. I mean, that's lawyerly stuff, has to be there, but it's not the client's main concern. So that's what I mean by front-loading contractual documents. Can we do the same in a contract as we do in a legal advice? And if we did, it would appear something like that, I think. Let me go to the next page. You should have 2 columns here. We're not going to read them, don't worry about that. But let's say we're drafting a commercial lease. And if you were to read this left-hand column quite closely, you would see the main clauses are all over the place. This is the table of contents from a lease that ended up on my desk maybe 6 months ago now. And it appeared to me that the order of clauses is completely random. Why on earth would you put them down in that order? I don't know. Some of them have just grown over the years, and for some reason, perhaps because the lawyer thought it doesn't really matter, it's there somewhere, that's enough. The order has remained fixed in some office precedent, and that's how they always come out. But if you wanted to order it more logically, maybe not front-loading, but grouping like with like, maybe that's the best way for a lease, then it would look more like this is my rearrangement on the right-hand side, where they've been grouped thematically. The topics have been grouped thematically. And maybe if you can later download a version of this talk or these pictures, you'll see what I mean. You can look at those in more detail. But it would be much better for the client, particularly as each grouping there on the right-hand side has its own heading. So you can see at a quick glance thematically what this content is and what that content is. It takes a lot of work at first to get these thematic groupings logically for the client. But once you've done it once, hopefully you don't need to do it again. The structure is there in all of your office precedents thereafter. And then finally, let me give you an example of a contract for the sale of land. I'm not going to go through the clauses, but an English judge once famously said a contract for the sale of land, at least in England, works out like a stately saraband, like some medieval dance of old, you know, pre-configured steps. They always follow one after another in a particular order. And that's my experience with contracts for the sale of land. There's a structure to way a contract, to way the contractual procedure unfolds. First, you have your exchange of contracts, what we do here. Then you pay your deposit. Then you investigate the title. Then you pay the rest of the money. Then you complete the transaction or settle the transaction. And then you fight about other problems later on. And so you could have a contract which follows those steps. And that would be a logical way for a contract for the sale of land, because everyone who's in that kind of business knows that's how they always work. That's a logical way to set out your contract. So where am I going with all of this? I'm saying that one structure doesn't necessarily fit all. You may want to front load, you may want to group thematically, you may want to adopt a chronological structure, but whichever you do, then you've at least given some thought to what's the best structure for my transaction. And from that can then follow attention to words, sentence length, matters like that, all of which are key. But you've started with a logical structure. My structure, then go back to my test as I started with, my structure then helps my reader through. They should be able to understand it on a first reading. And then finally, in my little talk this morning, let me take you to some other aspects of structures, which I think for parliamentary drafters, people who draft legislation are now coming to the fore, but for most of us who are in the back offices in legal firms, are still something new for us. Aspects of structure which might help my reader understand this on a single reading. One is, have you considered maybe a purpose statement or an object statement at the beginning of your contract? And here's an example. You can read it more at your leisure if you wish later on from an employment contract. It just sort of says the purpose of this contract is to do this, regulate our rights, and here are some of the main areas. It doesn't purport to summarize the contents that follow. It doesn't purport to stamp any particular interpretation on the document. It just says, dear reader, here's basically what we're trying to do, what you and I are trying to do in this document. A purpose statement, I say, is now more common in statutes. I don't know about American statutes, whether I can see Joe's face on the screen, whether you find these in American statutes now, perhaps. No, rarely, I think, perhaps. But it's quite common in Australia and in Britain and in New Zealand and in some of the Canadian jurisdictions. You start with this sort of purpose statement. It can be a bit generalized. It's not an attempt to, as I say, summarize what's in the act which is to follow. It just gives the reader a gentle lead in, as sometimes recitals can do, although they can be overdone as well. So that's one possible thing to think about. Another one which we use here in Australia, excuse me, is what we call a simplified outline. Here, dear reader, is basically what is in this act. It's not a purpose statement. The purpose of this act is to, which can help guide interpretation, as you know. This is just a simplified outline. As you read on, you'll see that we've covered these main points. I dare say, at the risk of self-publicity, blatant self-publicity, you'll find all these techniques discussed in some of the books that Mark very generously mentioned before. Or have you tried a flowchart in your contract, for example? Here are the steps in which, here are the steps how this transaction will unfold. This will happen, then this will happen. If this happens, then that happens, and so on. A flowchart, a really interesting way to help the readers follow the steps in the transaction, a flowchart. And this is my example, which I say you can read at leisure, perhaps one day if you wish, from our Australian native title legislation. How do I claim native title to this land? Well, if you're in this category, this happens. In that category, that happens. So the act itself, it's part of the act. It's not a schedule or an annexure or the politician's sort of handy guide to my act. It's in the act itself. It's the integral part of the act, a flowchart. Have you considered the best form of headings in this document? That's an aspect of structure to me. What will help my reader understand it? Well, you have to use generous headings, generous numbers of headings. Well, give some thought to the form of those headings. Could I have a question style heading? Could I have an information-rich heading, which actually tells the reader, in the form of the heading, tells the reader the essence of the clause that's to follow? And certainly give some thought to the provision we find certainly in interpretation clauses here and in Britain, I know, basically, my headings don't count. Dear reader, when reading this document, or dear judge, when reading this document, take no account of the headings. Headings are for information only, not to guide interpretation, something like that. You know that kind of clause. Well, why would you put that sort of clause in your document if you've really given serious thought to the form and content of your headings? So think about headings. Every page, I have a rule of thumb which I tell my students, every page should have at least one heading, whether it's an advice or a document, and chances are they do. But you know, there's nothing worse than picking up a legal document, a contract or an advice, which has several pages without any headings. You just think, even if the writer is actually very good, even if they're a Joe Kimble, it reads seamlessly. It looks like a hard read because there's not a heading in sight. Psychologically, it's distressing. Put generous headings. And then finally, definitions. I'll kind of end with this point. It's a whole topic in itself, but where you put your definitions is an aspect of structure. I think the trend is growing here now in this part of the world, Australia and in Britain and in New Zealand, that you try and get definitions or most of them out of the way. Don't start your document, particularly if it's a maybe 3 or 4 page document, that's all. Don't start the document with a page or 2 of definitions because it's so distressing for the reader who's not used to legal documents. You and I, if we pick up a document with which starts clause 1 definitions, we would probably scan them, make a mental note of what's there, but we wouldn't read them closely at that stage. We'd come back and check them from time to time as we need to. We wouldn't try and memorize them as we go. But a former colleague of Joe's and mine, Robert Eagleson, Dr. Robert Eagleson, who started Plain English here in Australia maybe 30 years ago, once did some research of lay readers' attitudes to reading legal documents. And he found that most lay readers approach a legal document in the same way as they would a novel. They feel that they have to read it page by page and master each bit as they go. Otherwise, they'll miss something. And so if the first clause, maybe 3 or 4 pages, is of definitions, they kind of feel they've got to read all these through closely, master them before they can read on. And that makes the document such an intimidating document to read. We don't, because we're used to these documents, I say we don't follow that linear approach, as Robert Eagleson called it. But you may find that your clients do. And so by putting the definitions up front, particularly if there are a lot of them, then you've really made your document intimidating. The structure is not a structure which is accessible to that particular client. So give some thought to where you put your definitions and the sub bullet points I have in that page. How do you identify your definitions? Where and do your definitions hide substantive provisions, which of course is something we know should be a no-no, but is a trap for the unwary reader and the careless writer as well. And then, as with my little question about headings, why would you say headings don't count? You know, we always have a provision at the end of our definitions which say, these words mean these things unless the context requires otherwise, or some writer to that effect. Well, again, if your definitions are really laboured over, thought over hard, why would you then say, well, the context, by the way, might mean that this word doesn't mean this in some particular part of my document? There may be reasons why you would want such a security blanket. However, it doesn't read well, does it, to the poor reader who's now gone through all these definitions, pages of them, only to find a clause at the end which says, oh, by the way, sometimes these words don't mean these things at all. So to me, that's also an aspect of structure. Where you're going to put them, that's the most important structural point, where you're going to put them, and be more careful about the way you phrase them. Do you need so many? Are you hiding substantive obligations? Give some thought to the content of these definitions, because that all goes to my question, which is on my last page. Well, I'll try and bring this together. What is the best structure for my reader? So none of this is to diminish the importance of the topics that Julie and Joe will be talking about when you get down to the detail of your writing. But if you were to step back and look over the content, look over the document as a whole, I think we should always be asking this question. Structure is important. Have I structured my piece of writing, advice, document, whatever it is, email? Have I structured it so that it is accessible to my reader in this sense, that they should be able to understand what I'm writing on a single reading? Then we can get a big tick. If we can get a positive answer to that, we can get a big tick from a plain language perspective. So that, Mark, is my sort of introductory little chat to the rest of the seminar. So, and I think hopefully it's a segue into Julie's talk. So let me try and unshare my document, and then I'll let Julie take over next. If that's how we should go, Mark.
Sounds wonderful, Peter. Thank you so much for your words of wisdom about structure. We did have a question, and I have to so far give the award to Nassim from New Zealand. It's 4:30 a.m. there. And I think you addressed Nassim's question about the location of definitions. And Cheryl has also put in some remarks about her handling of definitions in longer contracts. So I am curious, about, I didn't tell the audience that you've drafted laws for Uganda, Dubai, and Australia. And I'm curious whether your client is a country that needs better written laws or whether your client needs a lease contract. Do you find that they're receptive when you become a little more innovative with the structure?
I usually have to explain why I've become innovative, Mark. Yes, for example, if you're drafting a statute, as I've done in some places, the instinctive response of a legislator is, oh, definitions in our country are always first. So you have to explain that. Or some of the, even I think Joe might cover some of this too, some of the sort of hallowed legal phrases that they might expect to find in a document, in a statute, you've rewritten in plain English, which is a little bit unsettling, I think, to some people who aren't used to that. So they're receptive, but sometimes you have to explain why you've done it, and then usually it's not a problem. I have found.
Thanks again, Peter. Peter, you have my permission to turn off your camera and get a cup of coffee if you need. That is fully acceptable. And then we will.
I think Nazim might need it more if he's in New Zealand. Oh, Nazim.
And if other members of the audience are inclined, feel free to just put in the chat where you're watching from. We got a big kick last time out of seeing how many different countries were represented. And once again, we welcome you and thank you for being here at Western Michigan University's Kimble Center for Legal Drafting. I'm going to transition to our second presenter, Professor Julie Clement. And it is a distinct pleasure for me to introduce her. She's a deputy clerk with the Michigan Supreme Court. She is the current president of Clarity International, which, as many of you know, is an organization devoted to promoting plain legal language across the globe. International organization. She's also a board member for the Center for Plain Language and the International Plain Language Federation. She's a distinguished professor emerita here at Western Michigan University Thomas Cooley Law School. She teaches multiple courses in Simon Fraser University's Plain Language Certificate Program, and she is a subject matter expert in multiple projects involving court form revisions. We've started to work at the Kimble Center on revamping some of the state of Michigan court forms, some of the forms that are used very heavily, especially by unrepresented litigants. And Julie's been involved with that, and she's been such a wonderful addition to our working group. We're so lucky to have her. And we're so lucky to have her right now to present for us. So without further delay, I give you Professor Julie Clement.
Thank you, Mark. Let me try to share my video. There we go. Okay, so I'm going to jump right in where Peter left off and give 2 tips for focusing on your intended reader. In other words, the people who will be using your documents. We tend to want to write for some hypothetical judge who might someday be asked to interpret some part of the document. But first, that rarely happens. I think recently I read a statistic that said something like less than 0.1% of contracts end up in litigation. I don't know how accurate that is, but it's not very much. And second, our efforts tend to make things less clear for the intended readers. So my first tip is to draft for the reader and not a hypothetical judge. Okay, take this provision from a power of attorney. So this is 2 sentences. The first sentence is 54 words. The second sentence is 67 words. All of that to say that the agent has virtually unlimited power. So why not instead just say this? If you need to give exceptions after this, but just say it clearly and plainly. Tip 2, also having to do with readers, is to choose detail that the intended readers need. Okay, logically, it seems like novices would need more information, and we tend to try to do that. We try to give them more and more information, thinking that we need to bring them up to speed, but that's not effective because if you give them too much information, you're going to lose them or you're going to confuse them. So novices tend to need less information. You can always follow up if they have questions, but they need the basics and they need it in clear language so you don't lose them and so you don't confuse them. Take this excerpt, for example. This is from a Michigan Court of Appeals decision about a statute of frauds issue. It's well written as an opinion, but you should avoid the tendency to include and then explain all of the detail to a client, for example. Instead, pull out what's important. So I'll do this paragraph by paragraph. Here in this first paragraph, it tells us that a contract for the sale of land needs to be in writing, and it needs to be signed by either the seller or someone who is lawfully authorized by the seller in writing. Second paragraph tells us that the plaintiffs here didn't have that writing. Third paragraph, though, points out that there's an exception. If the principal is present and the agent is signing at the principal's request, then that's an exception. And it also goes on to tell about the facts in this case, that there was a question of fact as to whether the defendant husband signed the contract at the principal, his wife, at his wife's request. A client, though, needs, if you're going to explain this type of law, a client doesn't need to know a whole treatise on the statute of frauds, okay? Usually, an agreement to sell land must be in writing, and the agreement has to be signed by the seller, you or someone, your husband, for example, with your written permission to sell the land. Your husband didn't have that permission, but there's an exception to this rule. This agreement may fall into that, that exception. You were there when it was signed, and if your husband signed it at your request, this is what the other side is going to try to prove in court. So those were my 2 tips on readers, okay? But communication happens in a number of ways. Certainly words and sentences, but as Peter showed, structure communicates too. And I want to talk about a third element, and that's design. When we talk about the definition of plain language, we talk about the wording, structure, and design being so clear that an intended reader can easily find what they need, understand that information, and then use that information. So first, though, it's important to understand and accept, even though we might not want to, that things have changed a bit since Robert Eagleson wrote that about people tending to read from beginning to end. We are a lazier bunch, not everyone, but readers today tend to do something different. They tend to skim and scan. They're not looking to understand the entire document often. They're looking to find an answer to a question that they have, or typically they come to the kinds of documents that we write with some kind of a problem and they want that problem solved. So they skim and they scan until they find a place where they think they're going to find the answer. And then they stop, read a little bit to verify whether it's there. If they can't see it's there immediately, they continue that pattern, skimming and scanning until they find the answer. Good design helps a lot. So my first tip for good design is that one of the easiest ways to help them is to provide effective headings that visually chunk the information without overwhelming the content. Now, you're not going to be able to read the next few slides because they're Latin gibberish, but I want to illustrate that this is what people see when they face that wall of text that Peter was talking about, and they don't want to jump in. Even if you understand some of these words, you don't want to jump into that. It looks hard. Adding headings can help, but they need to be designed to guide the reader, to show the structure of the document. Here we have enormous headings that hide the text, and that's the important content. And then the spacing here, because it's so inconsistent, it suggests a different structure than probably was in the original. It suggests maybe that the first item might be more important than the other two, or that the other two might be unrelated to the first information or to the first bit. Here, on the other hand, we have a little bit more effective use of headings. No more than 2 font sizes larger for the headings, but we've used bold so that they stand out. We've used a little bit more space above the headings than below them. That tends to help chunk that information into those logical sections. The reader knows what each section is about, presuming we're not writing it in Latin and we're using descriptive headings. And they can easily skim for information, which really helps show that you respect how the reader comes to your document. Tip 4, also about design, is don't scream at your readers. Okay? Lawyers tend to use all caps to get readers' attention, but all caps actually have the opposite effect because they're harder to read and they have a tone problem. So readers actually tend to skip blocks of caps. Notice how this one seems to yell at you. It has that tone problem. But it's also more difficult to read than if we weren't using all caps. And here's why. Take a look at this top line. All caps take a much more consistent amount of space. Notice that they're all the same height and they're all basically the same width. So it's harder to differentiate between the letters. And the second line, if you add bold, it makes it worse. On the third line, if you then add underlining, worse yet. And you can see with upper and lowercase letters, even in bold, are much easier. Optometrists, I believe, will tell you that one of the reasons eye charts are with capital letters is so that optometrists can distinguish whether you can actually see and differentiate between, for example, a D and an O and a Q, or are you just memorizing the shapes of the letters? Tip number 5, and again, Peter talked about structure, but let's look at another way that you can make the structure more obvious by using white space to show that structure visually. In this next slide, I've copied a Michigan statute directly from the legislature's website. It has multiple sections, subsections, and subsections, but they're hard to see when everything is so crowded and everything is aligned to the left. Even with this enlarged version, it's still not immediately obvious that this is one section with 3 subsections. Obviously, lawyers, we're used to figuring this out, to looking for these clues, like the 1 and the A and the B and the C in parentheses, but many readers aren't going to be, and they're going to be intimidated by this. So I'm going to adjust the white space. The line spacing here is less than single spacing in the original. So I'm increasing it to just slightly more than single spacing. I'm going to increase the space between paragraphs from 10 point to 12 points. I'm going to indent the subsections. And then I'm going to use hanging indents to further define the subsections. And you can see we get something like this, which is much easier to read and much easier to see that structure that Peter was talking about, how important it is. Same thing for section 2 and its multiple layers. Showing the reader the structure at a glance shows respect for the reader's needs. And I have changed nothing about this except the design. I've merely improved the white space. And then finally, my tip number 6 is to not be afraid of visual elements. As lawyers, we tend to shy away from pictures and other graphics. Maybe we think they're less serious than that wall of prose that we're all so fond of. But virtual elements can be really helpful. Okay, so they can help organize and interpret information for the reader. They can highlight information. Maybe you want to emphasize something, or you want to make it more memorable for the reader if it's important information. Maybe they can quantify, abstract, or data-heavy information to make it easier for the reader to digest. Remember, the documents that we're drafting, we've studied the content. We know what's in there. It doesn't have to be as clear to us because we already know it. But when you put it before a reader who doesn't know it, you want to make it as easy as possible for that reader to find, understand, and use that information. Take a second to read this explanation of a certain type of traffic accident. I'll give you just a minute while I take a quick drink of water. Did you visualize this while you were reading it to get a better sense of what they were talking about? Can you see the cars in your mind's eye? Why not give your reader that benefit? You're doing the communicating, so it's your responsibility to do the work of helping the reader to understand. Isn't this easier? And certainly it's not unprofessional. And then finally, here's an excerpt from a lengthy report written by the United States Department of Justice after they investigated the conditions in Alabama prisons. Notice how dense the data is in this paragraph. Now, certainly, if you read through it, you can understand it. It's not difficult to understand, but it takes effort to follow it and see how the information is related. And you're not going to hold on to it in your head. Okay, it's a lot of dense data. Then that last sentence introduces more data. Correctional staffing levels have decreased over time, as shown in the following chart. And then they made it visible. It's a significant improvement over a block of prose. And readers are going to remember this. They're showing that staffing went from less than 80% of what was approved. So they were already short-staffed in 2013. And by April of 2017, they were less than 30% of approved staffing. That makes a big impact. So to recap, it's all about the intended reader, right? Draft for the intended reader and not some hypothetical judge who might someday try to interpret one or more of the pieces of some document that you wrote. And then choose detail that the intended reader needs, remembering that novices need less information. They need broader information, not more detailed information. And then second, use design to communicate, because it communicates as effectively as words and sentences. Headings that stand out and that show the visual structure. Don't scream at readers with all caps. Use white space to show that structure at a glance, how pieces are related, what fits with what's subordinate to what, and don't be afraid of the visual elements. And that's all I have.
Thank you so much, Julie. We have a question from New Zealand here. Naseem was wondering if you have any thoughts or strategies when we get to subsections and we start to approach where traditionally lawyers have used the little Romanettes. Is there any way to avoid that, rather than going into those kind of the little baby Roman numerals to get to those sub parts?
For me, I prefer to have more subsections to divide it more at the first level, so that you're not going beyond that 2, maybe 3 maximum, because that gets really confusing, especially if you get into the 3rd page of it and you're 4 columns over, right? You have to keep flipping back.
And I have one more question from me. And this is something Joe, I know Joe's thinking about this, but let's just pretend he's not here for the moment. When you work so hard on making sure that the white space is appropriate and reader friendly, and you work with the hanging indents to create those hierarchies, those visual cues for your readers, do you sometimes get frustrated or worse when it then goes off to a publisher or somebody else who's responsible for the final product, and they aren't diligent in respecting all that hard work and those decisions you've made?
It is frustrating. And it's equally frustrating when the pushback maybe from a client is, well, that takes more pages. and we don't want to spend the money on more pages. It's really hard to convince them that the improved clarity will save money in many, many other places, even if it does cost just a little bit more to print a little bit more or save, a few more bytes of data.
And you included saving money in your answer, so they have to listen to that, right? Well, thank you so much, Julie. I appreciate it, and we all appreciate it. Once again, if anybody came in late, welcome to the Kimble Center for Legal Drafting's annual seminar here at Western Michigan University. I failed to acknowledge that our president and dean, James McGrath, is here, and I want to thank him for coming. We are blessed to have a school president who used to teach legal writing and is interested and very knowledgeable about all these things we're discussing. So thank you, President Dean McGrath. Now I will turn over the cyber podium to Joseph Kimble, and let's see. I'll go through his bio here. He's a lawyer. How's that, Joe? Is that a good bio for you? Let me do this properly.
That's plenty, Mark. I'm happy to start right now.
Well, I won't let you though. I'll be quick though. Joe has taught for 30 years at Western Michigan University Cooley Law, has published extensively, given more than 175 seminars and presentations across the U.S. and abroad. Senior editor, former editor-in-chief of the Scribes Journal of Legal Writing, longtime editor of the Michigan Bar Journal's Plain Language column. I think we hit 30 years with Joe at the helm. Founding director of the Center for Plain Language, former president of Clarity. Won 2 Burton Awards for redrafting our federal rules, as I mentioned at the very beginning, as well as other awards. I'll just say a Lifetime Achievement Award from one of our national legal writing organizations, and also closer to home here, the John W. Reed Lawyer Legacy Award from the State Bar of Michigan. And I am very pleased to introduce and present my mentor and friend, Joe Kimble.
Oh, that's very kind. That's very kind. Thank you, Mark. Now on my screen, at least Peter's handout or slide is still up on the screen, but I take it, Audra, that will disappear once I share my screen. So, okay. So many thoughts are running through my head right here. On sub-levels, Romanettes, I'm going to be using examples from the federal rules here in just a second. We were constrained in the federal rules. We couldn't change the rule numbers, Rule 4, Rule 4A. Sometimes we couldn't even subdivide long sections into shorter sections because lawyers are so used to these numbers. So sometimes, and you'll see in the examples, we went to more parts and subparts and sub-subparts and Romanettes even. We tried to avoid it when we had no choice because we couldn't completely change the rule numbers. And as for headings, I've just written this not too long ago. I said, this is almost a direct quote, as I grow older and marginally wiser, I realize that structure is so important, just as important as words and vocabulary, and headings are such an important part of it is. And I said even when I wrote this that I think the biggest improvement we have made in redrafting all of the federal court rules. We're working on our 5th set now, federal rules of bankruptcy. One of the biggest improvements we made is in the structure. And but yes, as somebody just mentioned, the publishers will not follow the formatting. They won't use hanging or progressive indents, and that too becomes frustrating. But all you can do is give it to them and ask them to please follow the formatting, but most of them will not. So at any rate, with that, Julie and Peter, that was terrific. I'm now totally intimidated. You gave some terrific big picture suggestions, and my suggestions are going to be much narrower. I'm going to talk about two of the worst faults in traditional legal writing: the long sentence and unnecessary repetition. My tips are going to apply, especially, of course, to legal drafting, but some of them will apply as well to other kinds of legal writing, other kinds of legal papers. Some of the examples that I'm going to show you here in just a second are dense, and you're not going to be able to digest them here in just the few seconds that we have to look at each one of these examples. But I hope you will see you'll see the structure of what I'm trying to show you in these examples. And again, you can listen to this. You can go back if you're so inclined and listen to this recording at your leisure, and you can pause the screen and digest them more easily and more with a little more time. And by the way, when you do that, or if you do that, and you look at them and study them, you'll probably see ways to improve them. It is one of the painful aspects of legal writing and legal drafting that you can always go back. I mean, you could always go back and make it better. And indeed, as I was looking over some of these examples, I thought to myself, I could have done better on some of these anyway. Anyway, here we go. Okay, I take it you can see that? Yes? Okay, good. More hot tips for better legal writing and drafting. All of the examples and the excerpts that follow are from a book that Brian and Garner and I are doing called Guidelines for Drafting and Editing Legal Rules, which will be out maybe this year or next year. At the very least, I hope it doesn't come out posthumously. Okay, controlling sentence length. Now I'm going to give you some specific, you will see advice, of course, in all of the legal writing books to not write long sentences. And indeed, David Mellenkopf, who wrote the classic foundational book, The Language of the Law, said that the long sentence is law 6. That's one word, LAWSICK, law 6, oldest curse. And so I'm going to give you a few tips for controlling sentence length, specific techniques. The advice out there is strive for an average sentence length of fewer than 25 words, 30 words at the most. I think it tends to be at the higher end for legal drafting for whatever reason. But ideally, no more than 30 words on average. Very often, these techniques, these tips that I'm going to give you here in just a second, you'll be using more than one of them at a time. You'll be combining some of these techniques. But let's take a look. Let's pinch that out just a little bit. Fairly obvious one: break long compound sentences into 2 or more sentences. Don't hesitate to start a sentence with a coordinating conjunction. This is an old myth, as I'm sure everybody here knows, that you shouldn't start sentences with and, but, or any of the coordinating conjunctions. But it is indeed just a myth. But, a lot of lawyers still buy into it, and it's hard to explode the myth. But look, at the request of a party, should be at a party's request, ideally, the court can order witnesses excluded, or the court can do it on its own. It's easy. Just where the second independent clause begins, period, or the court may do so on its own. Court may order the depositions to be taken, comma, now the second half, and thereupon the depositions may be taken and used in the same manner, period. Here you don't even need the and, I don't think. A period just start a new sentence. Deposition may be taken and used as any other deposition. See, these are long sentences joined by a coordinating conjunction. Compound sentences or compound complex. The Attorney General may appear and be heard, but the Attorney General may not. Easy. Period. But we can do that. You can do that. Court shall dismiss the complaint, provided that. See, we're not going to do provisos, right? All the legal writing books recommend against using provisos for one reason, if we're seeing it right here, that it just tends to drag on the sentence. Another is that it can be ambiguous. You know, you don't know whether the provided that means if, but, except, period, but, if. So again, you don't need to understand the content of each one of these examples, I don't think, to see what's going on. This one is, I've got to skip some of these. So you're welcome, obviously, to review the recording and study them on your own. Second tip, pull exceptions and conditions into a separate sentence. There's no rule that I know of. I've never seen a court decision that says an exception must appear in the same sentence as the main rule. So, for instance, every defense must be asserted. We don't do shall in the federal rules, with one painful exception, which I don't have time to get into. Pleading shall be asserted, must be asserted in the response of pleading thereto, except that. Stop here. You can see my cursor, okay, Mark, where I'm pointing. I hope I'm not flipping back and forth too much with it. Period. But party may assert the following defenses by motion. This one's a little more challenging, but you've got two conditions. When a party is entitled to copies, well, there may be more, but there's at least two main conditions. When a party is entitled to copies and the clerk on demand fails to deliver the copies. Could you at least pull one of the conditions into its own sentence? If a party is entitled to copies, party may demand certified copies after the party pays for them. If the clerk fails to deliver, see, you've broken it. You've broken one long sentence into two still longish sentences, but certainly shorter sentences, by pulling this condition into its own sentence. I'll skip that one. Here you've got two conditions. On a motion made by a party or upon the court's own initiative. The court, and now comes, you've got these two long conditions before you get to the main rule. Court may order stricken, strike. Redundant, immaterial, impertinent, or scandalous matter. You can start there. Court may strike. Scandalous matter. Period. The court may act on its own or on motion made by a party. When you in a list, when you've got a choice of whether, when you've got a shorter one and a longer one, it's usually smoother. If there's no inherent kind of order to the items, it's usually smoother to put the shorter one first. Okay, so you pull both of those conditions into a convenient for the reader, a convenient vertical list. And again, I'm going to skip that one. I just don't have time to, again, these are excerpts from a forthcoming book. We want to give plenty of examples in this, but I don't have time to do them all here during my 30 minutes. Now this one too is fairly easy to apply, to put in place. Repeat a keyword or a summarizing idea at or near the beginning of a new sentence. This often involves converting a relative clause into a sentence. A relative clause, a clause that begins with which, that, or who. The application of the court for an order shall be made by motion. Here we go. Which shall be made by motion, period. The motion must. It's easy. You just stopped and started over again with something, a word, typically a word you were just using, or an idea that you were just talking about. And the three requirements, again, set out nicely in a vertical list. This is structure again. A party or intervenor must file a disclosure statement. That names and identifies, blah, 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 period. Must file a disclosure statement. The statement must name. This is a fairly easy revision. Again, I will skip that one. But basically, again, you're seeing the structure. You're repeating a key word. The court may strike. Oh, this is one we just looked at, by the way. And that's why I say that some of these examples, maybe most of them, involve more than one of these techniques, but you are just repeating the court. The court may strike. The court may act. See, rather than just one use of the court. Use an expression such as may do so or must do so to refer back. Now again, here, look, the court may determine, the court may do so. Okay. So you pull that long condition into its own sentence and then refer back with the court may do so. It'll be a little easier, I think, to get in this next example. The attorney for the government shall disclose certain evidence. Has to do it at least 15 days before the scheduled date of trial. It's fairly easy. The prosecutor must disclose. We changed attorney for the government to prosecutor. And then the prosecutor must do so at least 15 days before the trial. Stopped here, period. The prosecutor must do so at least 15 days before trial. Finally, last tip under this fault of traditional legal writing, probably one of the worst at the sentence level. Convert a long condition to a sentence that refers to the rule itself, which we call a reflexive reference. One of the hardest things to deal with in legal drafting is the long condition at the beginning of a sentence. See whether you can convert that. And again, you don't need to digest the content here, just to see the structure. This is a long condition, and just turn that long condition into a reflexive reference. This rule applies if a lien voidable under section, see? Then, if that condition exists, the surety must be joined. A so-called reflexive reference, or that's the term that we use for it. So that's on the long sentence. Now, some tips, some techniques for avoiding unnecessary repetition, and it's everywhere in traditional legal writing and drafting, as many of you will know. Needless repetition. Legal drafting is prone to this kind of clutter. Clean it up. We're telling you. Trust readers to get a shortened reference to a preceding item. You got to give the readers credit for having an ounce of candle power. Right? If you are referring to a magistrate judge's written order, you don't need to keep saying the magistrate judge's order. the magistrate judge's order. The magistrate judge's order. There's no other order in sight besides the magistrate judge's order. So you can simply say written order, the order, the order, the order. Now you say, well, okay, big deal. You know, you're only saving two words each time. Well, okay, they add up. But the other thing is that this kind of repetition is what makes much of legal drafting so unusual or odd or artificial, you know, not natural seeming or sounding. You know, we don't talk that way. We use shortened references and pronouns, which I'll get to here in a second. Shortened reference. This is from Rule 23 of the Federal Rules. Class action, very controversial rule. The court must approve any settlement, voluntary dismissal. We're talking here about a proposed settlement or voluntary dismissal or compromise. Now watch. The next time through, it's the proposed settlement, voluntary dismissal or compromise. The next time through, it's a settlement, voluntary dismissal or compromise. One more time, and then if that isn't enough, 3 more full references in this rule. It's easy, or should be fairly easy. Refer the first time to the following procedures apply to a proposed settlement, voluntary dismissal, or compromise, right? And from then on, it's the proposal, and even the pronoun it, and it. And by the way, this does not violate, I don't think, the rule, the principle that you shouldn't change your words unless you intend to change your meaning. You're not changing your meaning here. You're not changing your terminology. You're just shortening a reference to one thing, the same thing, the thing that you were just talking about previously. Tip number 2, pull the repetitious wording into a lead-in to a vertical list. Now watch this. You know, and by the way, these rules were drafted by the very top experts in their fields, whether it's civil procedure, criminal procedure, evidence, bankruptcy. And lawyers have a lot to learn about legal drafting. And I will say that as you probably gathered from, I'm digressing here a little bit, but as you gathered from Peter's talk, I hope, the United States lags. It lags many other countries like Australia and New Zealand and the UK in coming into the modern day of legal drafting. The capacity of individual to sue or be sued. Capacity of a corporation to sue or be sued. In all other cases, capacity to sue or be sued. Why? You don't need to repeat all 3 of those. Just pull it all into a lead-in to a list. Capacity to sue or be sued is determined as follows. For an individual. For a corporation. For all other parties. And you only have to say it once. Merge 2 provisions that are essentially the same. Now, this is a beautiful example, which again, you just won't have time to study. But trust me, all of this repeats is essentially the same in this rule on signing disclosures and discovery requests. And look, and why is that? Because in one, they put the disclosure. If you sign a disclosure, you certify that. That's what all this is about, signing and certifying. The disclosure is. And then they go to every discovery request. See? Signed, must be signed, and you certify that the discovery request is. Now, there's got to be a way to merge those, pull them together and say it only once. So you pull this and you pull this up here. Now, this is still pretty dense. I admit it, but every disclosure, that's this part of it, and every discovery request, That's this part of it. See, must be signed, and by signing, attorney or party certifies that with respect to a disclosure, it is. With respect to a discovery response or objection, it is. So you merge those two provisions. Basically, you have restructured this rule and merged all of that repetitious language. How about use a pronoun? Give pronouns a chance. I mean, I don't know why in traditional legal writing we fear pronouns so much, or lawyers have tended to shun pronouns, and I don't know why. Probably because there's an occasional case where a court said the antecedent of the pronoun is not clear. And so this scares lawyers, and they say, well, I better not use pronouns. Well, just make sure that the antecedent is clear. That's the lesson there. That's the lesson, not to avoid them altogether. It is not necessary to aver the capacity to allege. By the way, should mention this: these rules these are not consumer documents. These rules are drafted almost exclusively for attorneys. The bankruptcy rules have a good set of consumer forms, pretty good set of consumer forms, and when consumers need to do bankruptcy on their own, they tend to use the forms. So these are primarily, the audience for these documents is primarily lawyers and law students. And so we can use terms like affidavit and subpoena and so on. It is not necessary to aver the capacity of a party to sue or be sued, or the authority of a party to sue or be sued in a representative capacity, or the legal existence of an organized association of persons is made a party. Okay, when a party desires to raise, and here we go, we're off to the turtle races. When a party desires to raise an issue as to the legal existence of a party, and what's even worse, they repeat it not in the, they repeat these three items in a different order. I mean, talk about sloppy. They repeat it in a different order. See, legal existence, which was the third item up here, is the first item down here. So it's doubly bad, besides the repetition. To raise any of those issues, a nice demonstrative pronoun, you don't have to repeat them all. To raise any of those issues, a party must do so by, and here in it really, in a nutshell, just not only the repetition, but look at the different structure of these two rules. This is one main subsection. Here you've got a subsection with subsections and even 3 levels. See, well, actually, the third level is a vertical list. But just compare the structure, the look, the convenience to the reader of those before and after examples. Okay, I won't do that one. I'm going to go very quickly over this last one because I want to show you a few more pronoun examples, which will appear in a different part of the book, different kind of pronoun. Entry of a judgment or order. Omit a later reference altogether when it's clearly implicit. Talking about a judgment or order entered by a district judge, and the clerk has to send a copy, basically, to these people. Or this person, the United States trustee. Notice of a district judge's judgment or order. The clerk must promptly send a copy to the United States trustee. We know it's a copy of the judgment or order entered by the district judge. That's clearly implicit. You don't need anything there. You can just cut that all out. I think. Well, and we plan to in the bankruptcy rules, which are in process. A lot of these examples are from the bankruptcy rules because that's what we're working on at the moment. The U.S. federal rules of bankruptcy. All right, back to pronouns. When the antecedent is clear, don't hesitate to use a pronoun. And a pronoun is perfectly acceptable, it seems to me, within a vertical list as well. Look at this. Must file a notice of appeal or amended notice of appeal. The notice or amended notice. It. See, again, it's not so much the 3 or 4 extra words, it's the artificiality of it. It's just that we don't tend to talk or write that way. We use pronouns. Get a load of this one. A party may amend the party's pleading. Well, who talks like that? You know, a party may amend its pleading. And even within a vertical list, we got a little bit of resistance on this, but I think we're going to prevail on this. Court must decide whether to hear and determine the proceeding, to hear the proceeding and issue proposed findings of fact, or no need to repeat the proceeding. It's just it, even though it's in a separate part or a different item in the vertical list. Nobody is going to have, I don't think, any trouble with that, reader or court. And oh, lo and behold, we're right back to where we started because I pulled those last few examples from a different part of the forthcoming book. So those are my tips for shortening sentences and avoiding unnecessary repetition. Here they are. And I'm not going to read them all, but I have gathered them all in one place at the end.
And I believe our plan is to make the presentation materials as well as the recording available to attendees. So if people want to take a little more time to study these documents, then you'll be able to. We did have a question, Joe, and
now can you take me out of screen sharing, Audra? I don't seem to be able to do it myself here.
Joe, what are we going to do about the shall problem? We have a question from Nassim in New Zealand, and he's working hard on committees, rule committees, and is bumping into the same shall, prickly shall issues that everybody bumps into. What advice for dealing with shall or dealing with institutions or committees that say that thou shalt use shall?
Shall is one of the most hotly, Peter, I know will understand this, and Julie, is one of the most hotly debated and one of the most fiercely resisted of the plain language changes. We managed to get it done in the federal rules with one exception. We had to reinsert shall because they wanted to keep the ambiguity of the shall in a very important rule on summary judgment. And so they couldn't decide whether to use must or may. So they said, we'll just use shall. Let the courts work it out. While at the same time admitting that it was inherently ambiguous. It's right there in the committee report. It's inherently ambiguous. I think we've pretty much won the battle, the intellectual battle anyway, when it comes to statutes and court rules. There's still controversy among contract drafters, as some of you will know, who think that shall works just fine in contracts. So, but the resistance, I mean, I appreciate the resistance is fierce to changing this. And it's symbolic of lawyers' resistance to change. I don't have any advice except to say, look what they're doing with the U.S. federal court rules. Look what they're doing in countries all across the world. Why are we lagging behind when it comes to this? And you can point out that courts interpret, and you can read some stuff I've written, some stuff Brian Garner's written, the courts interpret it all over the place. It has been corrupted by misuse. Of course, we'll read it, it should mean must if you use it properly, but courts have interpreted it to mean may, is, should, all over the place. So there's some danger, let alone this is not the way people normally talk. Nobody says you shall go to your bedroom and study. I guess the tip I have, I probably lost the question, but the tip I have is Just you have to show people that it's happening. Peter, why don't you chime in on this, and Julie?
Well, Joe, here in Australia, and Nazim would be able to say also in New Zealand, I haven't seen a shall in a statute, I would say, for the last decade. And I don't think any of the larger law firms in this country or in New Zealand or in Canada now would use shall. It's disappeared completely. It was once a hurdle, as it obviously still is in some places, but once leapt over, we all move on, and it's just disappeared altogether. All of the parliamentary drafters' offices now in every state of Australia have their own manuals, how they write inside their office, and they all say never use shall. It's a long lost argument here in Australia, a long won argument here in Australia. It's disappeared altogether. Yes.
Well, I have a million questions I could ask our distinguished panelists, but we're a little over time now. And so I want to, first of all, say, hey, everybody in the audience, we really appreciate you and we appreciate your time. And we're so pleased that you could join us today. Thank you so much for your support of the Kimble Center. We hope that you've enjoyed this. I've thoroughly enjoyed this. I knew I would. I couldn't wait for this event. I want to thank our panelists, our speakers, Peter, Julie, Joe. Fantastic, just as advertised. Thank you so much. And with that, I would say this is the end of our annual seminar. We'll look forward to seeing everybody again next year, and we'll have more great topics and speakers. And in the meantime, don't be a stranger. Feel free to drop us an email and say hello and let us know what you're working on. But again, thank you everybody for joining us here at Western Michigan University, Cooley Law School's Kimble Center for Legal Drafting. And be well and take care, everybody.